Hello and welcome again to our second lecture of this lecture series on the subject of Constitution. My name is Taimur. I'm an attorney at law, and my areas of specialization include environmental law, corporate law, and most importantly the Constitution. So previously we touched base with the premise, with the idea of the Constitution, and we also talked about Magna Carta, which is a product, or rather was the product of an uprising. Now, one of the interesting features of the Magna Carta was that the rights and the privileges which were secured through negotiation were to be extended to only 25 of the most wealthiest landowning barons. However, nonetheless, the Magna Carta is regarded by the historians to be amongst the most important constitutional documents that played a pivotal role in shaping the constitutional framework of the United Kingdom at present. We also covered clause 29. We talked about where there was a provision which said that no free man shall be arrested, detained, or seized of his possessions without or except by the lawful judgment of his peers, which perhaps in the history was one of the first times that a limitation of such sort was placed on the executive power of the king. And there was another interesting feature which provided for constituting a committee comprising of those 25 landowning barons, and the provision goes something to the effect that the king cannot raise taxes without consulting some senior members of this committee, and so on. Now, another great constitutional document was the Petition of Rights. This was issued in the year 1628. And if you think and look back about the 17th century, especially during the reign of King Charles I, who was actually on the throne, this era was marred by a great deal of controversy. There was an ensuing struggle in between the parliamentary forces on one hand, led by Oliver Cromwell, and the crown headed by King Charles I. And so during the 30 Years' War that King Charles I got caught up, as most of the European countries did, he was running out of capital and he needed the parliament to approve some sort of subsidies to help alleviate with the war situation. But the parliament wouldn't approve, and so the King Charles I started securing forced loans. These loans were taken without the approval of the parliament, and if anyone was unable to repay, he would be arbitrarily be imprisoned, detained. And apart from this, he also started billeting soldiers, that is another way of saying stationing soldiers, troops, into the private houses belonging to private citizens, even in peacetime, and started declaring martial law in different areas, which was something that certainly was of concerning nature to the parliamentarians. And so they got together, they drew petitions, they moved resolutions. They wanted to have the king review and appreciate, or rather respect, the principles which had been achieved through Magna Carta and the Habeas Corpus, which was another ancient writ petition. And so this Petition of Rights was drawn, and the king finally approved in the year 1628, and the chief among the provisions were that the king cannot take forced loans without the parliamentary approval, or that he cannot go on declaring martial law or imprisoning people based on his own whims, that he has to respect. And these liberties again were secured through this great constitutional document. Afterwards, England went through a civil war, and the forces of Charles I were defeated. He was executed at Whitehall, and his son Charles II took the throne. However, his forces were also defeated by the Cromwell forces, and so he went in exile in France. Cromwell took over, and for a very brief period in the history, the United Kingdom actually became a republic. It became the Commonwealth of England, and then it came under the Protectorate under the Lord Protector Cromwell, who actually became dictator and became just as tyrannical as any other king. However, after his demise, his son took over, but since he didn't enjoy support either from the army or the parliamentarians, his reign was rather short-lived. And so Charles II was invited back to come and take his position, take his place as a reigning king of England, which he did so. And then another constitutional important document was the Habeas Corpus Act of 1679. Now, habeas corpus is just another way of saying that if someone has been arrested or detained illegally, that I would petition the court. In my country, in this Pakistan, we'd pray for issuance of writ of habeas corpus and request the court to direct any person in whose custody a person has been detained illegally to be produced, and for the court to see whether such detention is illegal or unlawful. And so in this Habeas Corpus Act, which otherwise was recognized through common law or through customs, now for the first time it was given approval. It was recognized statutorily by the Parliament, and it became part of the Constitution, as we say. Another great constitutional document was the Bill of Rights of 1689. But before we can understand the Bill of Rights, it is important to understand the glorious revolution that took place just 1 year before, in 1688. It is as I say, that if a constitution is to be fully appreciated and understood, its historical context must be appreciated. So in Europe, since the 2nd century, the whole of Europe was mainly Catholic. But this all changed during the 15th century, when a German monk by the name of Martin Luther went and had difference of opinion with the whole way indulgences were sold, and his views on sacraments, which stood in contrast to those of the cloth and the clergy. And so he wrote his 95 Theses, which pretty much set in motion a chain of events. A new movement was born, the Protestant movement, and Lutheran churches and many other churches sort of broke off from the Roman Catholic Church. Now in England at that time, the people predominantly living were Protestant, and so they didn't like the idea that anyone who, should he were to be given the crown, should be Catholic, because their liberties somehow, or religious freedoms, may come under attack, and so on. So after the death of King Charles II, it was James II who was actually the second surviving son of Charles I. His brother Charles II, since he had passed away, so now the crown was given to him. But his party men felt that he was pro-French, and most importantly pro-Catholic, but that didn't really matter that much, until such day that he produced a Catholic heir. And so eyebrows were raised, and a coup was sort of restructured. And so they had William of Orange come from the Netherlands to invade and take the crown away from James II, and he married Mary, who was the eldest daughter of James II, and they sort of became the joint sovereigns. And William of Orange is a person who has quite a lot of history, a lot of squibbles and quabbles with the French Louis XIV king, who was also the Sun King. Anyways, long story short, before Mary and William of Orange were given the crown, there was a condition that they had to agree on, and this condition was in the form of a petition, the Bill of Rights. The Bill of Rights further secured certain freedoms. Chief among them were that there would be free elections, that if taxes were raised without parliamentary approval, they shall be illegal. There shall be no standing army unless approved by the Parliament. But one very important feature of the Bill of Rights was Article 9, which was the parliamentary freedom of speech, which even to this day is followed, and the mother document, the source of the origin, comes from the Bill of Rights, that no parliamentarian should be in any way sacked, or there shouldn't be any civil or criminal liability in regard to his legislative duties when he is on the floor and saying things or debating in discharge of his legislative duties and so on. So this was a very important freedom. Now, apart from the Bill of Rights, there were other statutory acts passed by the Parliament, including the acts of 1911 and 1949, which essentially limited the power of blocking legislation by the House of Lords. They gave more power to the House of Commons and said that in certain instances the approval of House of Lords isn't even required. So now, all in all, the documents that we have covered and talked about, starting from Magna Carta, the Petition of Rights, the Habeas Corpus Act, the Bill of Rights, or other parliamentary acts, they are considered to be among the most important constitutional documents. But one would wonder, these various acts of Parliament, how do they constitute the Constitution? Because in our country, Pakistan, if acts have been passed by the Parliament, they're only parliamentary acts, they're statutory law. They're not the Constitution. But in United Kingdom, they do form a part of the Constitution. See, in the United Kingdom, there are 4 different sources of constitutional law. The first being the statutory law, all the laws which have been passed by the Parliament, which have the functions of setting out the functions of the principal organs of the state and so on, defining the characteristic different branches, they will be considered as part of the Constitution. Second, you would have common law, which is another way of saying judge-made law. So if there are precedents, a case has come before a court of law, it has been decided in a certain way, then the way and the manner in which it has been decided, it is the law. So if any other case subsequently comes tomorrow fitting the bill, the same precedent would apply, and this is usually referred to as the common law. Third among the list would be the traditions, the customs which have acquired and attained the status of law. These are usually conventions which have been followed over a great period of time. For instance, it would be the monarch who gives the royal assent to a bill before it becomes law, or it would be the monarch who invites the leader of the house to form a government, or that a money bill originates in the House of Commons, and so on. And fourth, there would be the works by different authors and treaties. For instance, A.V. Dicey, of his works on the rule of law, even though the concept of rule of law conceptually was developed throughout history way before, but the shape that he gave, the idea that law should govern everything, that everybody is subject to law, nobody is above the law, and that if your case comes under a certain specific set of facts, then the applicable law would only apply, the law would govern and nothing else. And so these primarily could be considered as the 4 main sources of the constitutional law. Now, some of the principles of the British constitutional law are that they have a concept of parliamentary sovereignty, which is one way of saying that the parliament is supreme, that the parliament can pass any law, and that nothing, no institution could challenge such a law. The parliament is by far the supreme law of the land. There is no concept of judicial review. It isn't that if a statute is in violation, it stands in contrast to certain fundamental rights, that those laws could be struck on the basis that they are a violation of the Constitution. They don't have a concept of judicial review. The Parliament can pass any law and it can never be challenged. This is one of their basic concepts. Another one is perhaps the rule of law, which I explained, that the law should govern. And this was primarily very important when people started asserting and demanding their rights and freedoms. They have a unitary form of government. They don't have a federal structure. Any power that the federating units, if I may, have are the powers that are given to them by the center. These powers are delegated to them. They don't have any power of their own. They have a parliamentary form of government, which is again something we have, where a distinction is made that the head of the state would be the sovereign, would be the president, and the head of the government would be a member of the parliament who would have those powers. And there is no concept of absolute monarchy. There is a constitutional monarchy. There are checks and balances. There are rights of people that cannot be trampled upon, and so on. You know, when I was doing my master's in law from the University of California, Los Angeles, I distinctively remember having this conversation with a good professor of mine, and we were randomly talking about different subjects of law, and the subject of constitution came up, and he said that if the United States never had a written constitution, they never would be here where they were today. Because of so much chaos, anarchy, the fact that there could never be any consensus and ambiguity, it would be difficult. And I agreed with him, and I also said that despite the fact that the United Kingdom doesn't have a written constitution, they managed to keep the system together. And they never let this shortcoming come in the way of protecting and promoting the civil liberties of their citizens. But this achievement of theirs in protecting and promoting the civil liberty, this process hasn't been so easy. It has, but for a great deal of struggle and sacrifice, been realized. You know, many people think that perhaps it was the Magna Carta that started it all, it started the democracy. I mean, it wasn't the starting point, but it certainly was a step in the right direction. Now, another important milestone event was the Peasants Revolt of 1381, where a poll tax had been levied to pay for war with France, given how much the United Kingdom and France loved to go to war with each other. And the people rose up and they said, we are not going to pay this poll tax, and so they organized a protest movement and forced the king to listen to them in a sort of Magna Carta style fashion. The king agreed to them initially, and then when they turned around, the king had all of them slaughtered. Now, perhaps this is not the best example of organized protest, but at least the idea of drawing strength in numbers grew strong, this momentum, this force. Now, in the year 1295, Parliament as such as was summoned for the very first time, not many members could cast their vote or be represented. In terms of the general population, very few minority amongst the community were from nobility or otherwise that actually had that authority. It was a different age altogether. There was a very famous jurist by the name of Paine, and he wrote his book, The Right of Man. And he said that the government cannot be the property of one man or one family, but that belongs to the whole community. And this book of his was considered as seditious and was burned away. Such was rather the state as was in force. Now, another important event was at the start of the 19th century, in 1830s, early 1830s, when there was an ensuing struggle between the landowning barons and the people who were employed by the landowning barons to work on their cottages. Now, those people, with the passage of time, became somewhat disgruntled, and they said that we want more rights. And they organized some of these movements along with each other. They established trade unions and had secret oaths which were only invalidated later on by the magistrate. They were punished. They were sent to Australia to serve their prison sentences. And people opposed this measure and came out and protested in great numbers. And the executive knew that they had to give in, that they have to cave in this time. And so this idea of fighting for their rights was now becoming very popular. Now, in 1832, in the year in Great Britain, only 2% of the whole population actually had the right to cast their vote. Only 2%. And so from the movement which started from 1838 to 1848, finally the right to vote and the right to exercise adult franchise was given to the men. But the women said, what about us? Where do we go? We also need that right. And so they started engaging in hunger strike. They started coming out in large numbers and protesting and so forth. And the situation became so wary that at some point the government actually passed a cat and mouse act. They said that if a woman was incarcerated and she was on hunger strike, she would be allowed to be released just so that she could have another meal and then she can be put back in prison. Such was the state. But finally, it wasn't after the First World War when for the first time the right to cast vote was given to women. But it was done so with the condition that they could only do so unless they had attained the age of 30. Men said that we cannot trust the women until they're a little old enough. I mean, you never know, they might vote for Tories or so. But they again came out and they said, this is complete rubbish. We want our rights and we must be treated equally. And so it wasn't until 1928 when finally women were given the same rights, that they could cast their vote just about the same age that men could be. Now, I'm going to wrap up my lecture here today for now, but in our next lecture we're going to talk about the American Constitution, and if there are any comments, please feel free to share. I would just like to say one last thing, that all the examples that I've given so far tell us and teach us that in history, if it isn't for struggle and sacrifice, nobody really goes out and share power or rights. Thank you very much.